આરોપીને મોબાઈલ નું કનેક્ટિવિટી કયા કોની સાથે હતી? કંઈક એકાઉન્ટ હશે ને? ના ના, એ નહીં, એ મોબાઈલ એ નહીં, એ તો છે બધું. આ મોબાઈલ નો નંબર કોક ઈમેલ સાથે કનેક્ટેડ હશે ને? એ વેરીફાઈ કરીને કોને નેક્સ્ટ વેરીફાઈ એ એના સિમ પણ કરી લો, અને બીજું કે પેલો દરેક ફોન ને એક્ટિવેટ કરવા માટે એક ઈમેલ નાખવો પડે. એ કોનો છે? then your તમારી પાસે બિલ નથી ઓરિજિનલ? ક્યાંથી લીધા હતા ને એવી વિગત છે? ના ના વાંધો, તમે આટલું લઈ લો, તમે આ એડિશનલ કરજો, ખાલી એફિડેવિટ થી નહીં ચાલે એવું. લો
મારું નામ નથી
મોહન એ બ્રિજ મોહન વાસુદેવ અગ્રવાલ
મોહન
ચાલે મોહન અગ્રવાલ નામ છે એ જ હાલના આરોપી છે. એક પ્રવીણભાઈ ચિમનભાઈ પટણી નું નિવેદન છે.
બરાબર.
એમાં નીચે
17/11
હા
21
અહીંથી વાંચો છે. ત્યારબાદ ભારતીબેન ચિમનભાઈ પટણી સાથે મોહન અગ્રવાલ રહેવાસી અર્બુદાનગર જે એમનું રહેઠાણનું છે સરનામું રાજેન્દ્ર પાર્ક હોટલ અમદાવાદ નામનો વ્યક્તિ કામ કરતા હતા. તેઓ બંને જણાએ જે લાભાર્થીને આવાસના મકાનના નાણાં આપેલા તે લાભાર્થીના પરિવારના ફોટા પાડેલા હતા. તે ફોટા અમદાવાદ મ્યુનિસિપલ કોર્પોરેશન શહેરી ગીરા આવાસમાં કબજા સોંપણી પત્રમાં લગાડવામાં આવેલા હતા. અમે અમારા જેવા બીજા ઘણા લાભાર્થીને આવાસ કબજા સોંપણીના પત્રની નકલ આપેલી. લગાયા પેલા કબજા સોંપણી
નથી.
ભારતીબેન અને મોહનભાઈએ સાથે કામ કરતા હતા પહેલા અને બંને જણાએ લાભાર્થીના આવાસના મકાનના નાણાં આપેલા.
એ પોતે
તેઓ બંને જણાએ જે લાભાર્થી મકાનના નાણાં આપ્યા તે લાભાર્થીના પરિવારના ફોટા પાડેલા. એટલે લાભાર્થીના ફોટા પાડ્યા. એ ફોટા અમદાવાદ મ્યુનિસિપલ કોર્પોરેશન શહેરી ગરીબ આવાસ કબજા સોંપણીના પત્ર ઉપર લગાવ્યું સાહેબ. એ લગાવ્યા પછી એક કબજા સોંપણી પત્રકની નકલ આપી અને એ કબજા સોંપણીના પત્રકમાં આવાસનું નામ અરજી પત્રનું નામ સરનામું વગેરે લખ્યું અને પછી આવાસ ફાળવવામાં જાહેર કોમ્પ્યુટરમાં ડ્રો તારીખ 14/6/15 ના રોજ કરવામાં આવેલો ઉલ્લેખ કરેલો.
એને ક્યાં કર્યું? He is also one of the victims, Your Honor. He has some documents are there. Well, more. તારા બી પૈસામાં ગયા એના ના ના એ નહીં થાય. હું એની પાસે છે કે એના પૈસા બીજા એમાં ગયા છે. બેસ બેસ બેસ. Victim says, I am also victim because I have deposited the amount and receipt was given by these accused, Your Honor. I have supplied that document. Investigating officer, I have submitted that document. But looking to the charge sheet, that document does not appear. હવે તો માની લો સાહેબ મેં ફોટા પાડ્યા હોય તો વોટ ઇઝ માય ફોલ્ટ, યોર ઓનર? ના ના હું આપને કહું છે સપોઝ જી he is also victim, your honor. I have submitted the document with police, your honor. Copy has, I have copy. Copy is there.
18 સાક્ષીના નિવેદનમાં નામ છે સર.
Copy is there.
જી 406 467 68 471 અને 120B. સાહેબ એમના પાસે કોઈ પાવર નથી. એમના આવા મકાનો આપવાની યોજના કોઈ કોર્પોરેશન મારફતે એમને કોઈ આપેલી નથી. બધું હંબગ સાહેબ.
એવું ક્યાં છે પેપર, એમાં પેપરમાં કે નહીં?
ના આરોપી નહીં, ટોટલ ની વાત. અને કોર્પોરેશન ને એવું કોઈ એમના એજન્ટ કે એવી કોઈ નિમણૂક કરેલી નથી. જયસુખભાઈ, ભારતીબેન અને બ્રિજમોહન ને દાડમબેન ને સહીદાબેન 6 આરોપી. હાજી આ પુરાવો છે મેં કહ્યું એ. ભારતીબેન ના સાથે સાહેબ. કહું સાહેબ. ના સાહેબ આપું ભારતીબેન નો રોલ આપી દઉં.
અને ભારતીબેન આઈ થિંક ઇઝ એક્સપર્ટ. આડમબેન ભારતીબેન કદાચ એક્સપર્ટ છે.
એક નિવેદન વાંચું છું આખું
એવું છે?
ગમે તે.
ના, મને ગીતા પણ મને બતાવો.
હા એ નહીં વાંચું છે. શાહિદાબેન નામના મહિલા શહેરી ગરીબ આવાસના મકાનો સસ્તામાં ₹1,25,000 માં અપાવે છે તેવી જાણ થતા મારી માતા એક વિક્ટીમ છે. એ શહીદાબેન પઠાણને મહિલા સાથે સંપર્ક થતા શહીદાબેન પઠાણે પોતે સીમા મહિલા સેવા મંડળ ચલાવે છે અને ગરીબ મહિલાઓને મદદ કરે છે એવું જણાવેલ. અને શહેરી ગરીબ આવાસ મકાનની કિંમત 1,25,000 જેટલી છે. 1,25,000 જેટલી 3 હપ્તામાં ભરવાની હોય છે. મારી માતા આવાસની મકાનની સ્કીમ સમજાવેલી અને મારી માતાએ મને શહેરી આવાસ મકાન 1,25,000 માં મળતા હોય આપણે લેવાનું જણાવતા અમે સંમત થઈ મકાન લેવા ગયા. મારી માતા અને સહીદાબેન નામની મહિલાએ અમારા ઘરે આવેલા તેમની સાથે જયસુખભાઈ પરમાર વન ઓફ ધી એક્યુઝ નામની વ્યક્તિ અમારા ઘરે આવેલી. તેમને જણાવેલી કે શહેરી ગરીબ આવાસ મકાન 1,25,000 માં મળે છે, જેમાં એક મકાન દીઠ રોકડા 15,000 આપવા પડશે તેમ જણાવતા અમે સૌ પ્રથમ 15,000 રોકડા જયસુખભાઈ નામની વ્યક્તિને મારા ઘરે આપેલા. એમનું પૂરું નામ સરનામું જયસુખભાઈ તુલસીભાઈ પરમાર હોવાનું અને પોતે મ્યુનિસિપલ કોર્પોરેશનના અધિકારી છે તેમ જણાવેલ. અને તેની સાથે આવેલ વ્યક્તિ રાજકુમાર દુબે જણાવેલું હતું. જયસુખભાઈએ જણાવેલ કે શહીદાબેન પાસે ગરીબી આવાસનું ફોર્મ ભરી જે ડોક્યુમેન્ટની ઝેરોક્સ નકલ માગેલ તે ફોર્મ ભરી આપી દેજો, તમારું કામ થઈ જશે. ત્યારબાદ શહીદાબેને ગરીબ આવાસનું ફોર્મ ભરાવી અમારા ડાબા હાથના અંગૂઠાનું નિશાન લીધું અને ગરીબ આવાસ મકાનના ફોર્મમાં આધાર કાર્ડની નકલ, પાસપોર્ટ સાઇઝનો ફોટો, ચૂંટણી કાર્ડની નકલ, રાશન કાર્ડની ઝેરોક્સ આપવા જણાવતા અમોએ શહીદાબેનને ઝેરોક્સ નકલ આપેલી હતી. થોડા દિવસ પછી અમદાવાદ જુદા જુદા આવાસ મકાનો તૈયાર થતા તે મકાનો બતાવેલા અને આ આવાસ મકાનો તમને ફાળવવામાં આવે છે. ત્યારબાદ ભારતીબેન ચમનભાઈ પટની સાથે મોહન અગ્રવાલ હાલના અરજદાર સાહેબ રહેવાસી અર્બુદાનગર રાજેન્દ્રબાદ નામની વ્યક્તિ કામ કરતા હતા. તે બંને જણાએ લાભાર્થીઓના આવાસના મકાનના નાણાં આપેલા. તે લાભાર્થીના પરિવારના ફોટા પાડેલા, જે ફોટા અમદાવાદ મ્યુનિસિપલ કોર્પોરેશન ગરીબ આવાસના કબજાની સોંપણી પત્રમાં લગાડવામાં આવેલા હતા. અને અમારા જેવા ઘણા લાભાર્થીને આવાસ કબજાની સોંપણી પત્રકની નકલ આપેલી, જે લાભાર્થી કબજા પત્રકમાં આવાસનું નામ, અરજી પત્રનું નામ, સરનામું, વિગત લખેલી આવાસ ફાળવવા જાહેર કોમ્પ્યુટર ડ્રો તારીખ 14/6 ના રોજ કરવામાં આવેલ તેવો ઉલ્લેખ કરવામાં આવેલો. 7 જેટલી શરતો બતાવી. છેલ્લે ડેપ્યુટી કમિશનર એક્ઝિક્યુટિવ ડાયરેક્ટર FRCS નો હોદ્દો છે તેવું અવાચ્ય સહી વાળું જયસુખભાઈ પરમાર રાજકુમાર દુબેના કહેવાથી અમદાવાદ શહેરી સત્તા વિકાસ મંડળ નામના 7,500 નો ડિમાન્ડ ડ્રાફ્ટ કરાવેલ. જે જોતા વિજય બેંક સરસપુર તારીખ 28/2014 નો ડીડી મુજબનો છે અને રિવરફ્રન્ટ ડેવલપમેન્ટ નામના 15,000 નો ડિમાન્ડ ડ્રાફ્ટ કઢાવેલો. તે જોતા વિજય બેંક સરસપુર શાખાનો આટલા મુજબ છે. જે બંને અમારા ડિમાન્ડ ડ્રાફ્ટ જયસુખભાઈ ને રાજકુમાર દુબેને આપેલા. ત્યારબાદ જયસુખભાઈ ને રાજકુમાર દુબે આવાસ મકાન પેટે નાણાં જમા કરાવવા ડેપ્યુટી મ્યુનિસિપલ કમિશનરના ડેવલપમેન્ટની સહી વાળો પત્ર આપવામાં આવ્યો. જે પાવતી બુક નંબર 5 નંબર મને યાદ નથી. પાવતી બુક નંબર અસલ જયસુખભાઈ પરમાર અને દુબે અને મોહન અગ્રવાલ પાસે છે. ગરીબ આવાસની કિંમત 1,25,000 3 હપ્તા ચૂકવી દીધેલા હોવા છતાં મકાન અમોને આપેલ ન હોય. ઘણો સમય થઈ ગયેલો હોય. એટલે સાહેબ ભારતીબેન, મોહન અગ્રવાલ, દાડમબેન મોહનભાઈ, સઈદાબેન એ 6 જણા છે ટોટલ.
ભારતીબેન દાડમબેન ઇઝ એબ્સકોન્ડિંગ.
આ જે હોય
હા,
આવશે તો
સાહિદાબેન પછી ભારતીબેન અને દાડમબેન 3 જણા એબ્સકોન્ડ.
ટોટલ સાહેબ 23 જણાના નિવેદન છે. સામેલ. અને સાહેબ એમને જે એ કહે છે ને હું વિક્ટીમ છું, તો આ તો ચાર્જશીટ નો પાર્ટ નથી, પણ ભારતીબેન નું નિવેદન છે. એમાં એવું લખ્યું કે આ 3-4 જણાને મફત મકાન આપવાના હતા એવી લાલચ આપી જે એમના જોડે હતા. એટલે અમને મફત આપવાના.
to a schedule of rents for the value of any such property or where such property is taken or held outside the country, then the property equivalent in value has its property. Okay. So schedule proceed of crime will mean any property derived directly or indirectly from a schedule offense. That is very clear definition. And schedule offense has been defined in section 2(1)(y). The offense under part A of the schedule, for the offense specified under part B of the schedule, if the total value involved in such offense is 1 crore rupees or more, for the offenses specified under part C of the schedule to the PMLA. And section 3 is also going to be well known for still at least section 3 of PMLA. Whoever directly or indirectly attempts to induct or knowingly assist or knowingly the party or actually involved in any process or activity connected proceeds of crime, including concealment, possession, acquisition, or use and projecting or claiming as untainted property shall be guilty of sexual nature. So now, sir, one thing is very clear that to punish anyone or to charge anyone under the PMLA, it is necessary that there has to be proceeds of crime which is connected with a schedule. Now, can you see the applicant before your honor is a person who is 80% disabled. That is an admitted fact by the prosecution also that he is a person with 80% disability.
Now, why is it submission of disability?
Just
Because it won't have any.
so that is also one of the important factors because a person
Yes,
is
therefore I'm asking.
80% disabled, he is not normally able to discharge various functions. His mind and body will not work in a proper manner. That is my solution. Because a disabled person and that too up to 80%.
What is the disability?
Disability, he is in a wheelchair.
No, wheelchair, but paralyzed or
Certificate, I think certificate has been produced.
because you make a submission, therefore
No,
for consideration.
I will show the same.
Yes.
He is
You can-
wheelchair, he is into wheelchair, he is not able to move here and there on his own. Now kindly see, sir, my discharge application, wherein I have given a table in para 3 on page 2. These are the FIRs which are filed against various accused. I am accused number 7. And discharge application is only with respect to accused number 7. Now kindly see, sir, the first FIR, which is dated 16/3/2015. The present applicant is not accused in this criminal case. So may I just point out that
Para 3, there are total 9 FIRs.
yes,
Okay.
out of that, 2 FIR have been posted by the Honorable Gujarat High Court, that is 8 and 9. In all these 7 FIR, which is made,
So now 1 to 7 remains. Yes.
either I am not one of the accused in the FIR, or that no charge sheet has been filed against.
You are not an accused or charge sheet is not filed.
Now, at least because there was applicant 1, 2, 3, applicant is not an accused in any of the FIRs, then 4 and 5, order dated number and directing no purchase step to be taken. Now, 4 and 5, and 4, 5, and then 6 and 7 have been, there have been cured. No, directing no persistent to be taken, these petitions were filed by the accused number 5. Who is the brother of that? So my humble submission is that at this juncture, or at the juncture of invoking provisions of PMLA, there was no schedule offense
Yes.
against the applicant, that is accused number 7. That
Your-
apart, the only allegation in the entire complaint is that after the main accused, that is accused number 5, with trigger of accused number 7, had allegedly fled from the country, he had taken over the management of one of the company. This is the allegation. And that he has disposed of various movable assets, etc. Though no description or any value has been given. It's an absolutely general allegation that some movable assets have been disposed.
You are
There is a
accused,
specific allegation.
you are accused number 7.
I have-
Yes.
There is a specific allegation that a plot of land valued 14,000 land, valued about 17 lakh rupees. And as per government assessment, it was valued about 30 lakhs. Have been transferred by the company in the name of the FIR, in the name of wife of the accused number 7. That is one of them.
One allegation that property,
For around 16-17 lakh was transferred by one of the company to the wife of the accused, that is, that the wife of the accused. That is one allegation. Second allegation is that he transferred one OD car, old OD car, for rupees 9 lakh during that period. Sort of disposed of or transferred. That is another allegation. I could not find any other allegation. These are broadly the allegation, but if we read the entire complaint as a whole, then it does not appear that there is any direct allegation against him. General allegation is there.
as per your say, first, some property is transferred in your wife's name.
Twice.
And
So
sec-
not transferred in mine.
your wife's name. And secondly is that one OD car
Valued around 9 lakhs.
that was disposed by you.
By the applicant. Because that must have been disposed in the name of the company. Not by me. Or probably I might, allegation is that I have acted in disposing of that car.
Like you have sold away or it was company's car?
It was company's car.
Company's car. Okay. So these are broadly the two.
And third allegation is that after taking over, after accused number 5 had fled, allegedly fled, he had disposed of some movable assets of the company as per direction of accused number 5. These are the allegations.
Yes.
Now my submission is that in backdrop of these facts, my first submission is that this person being a 80% disabled person who is not able to perform functions normally, regularly, and therefore he cannot be expected to attend to the business of the company and perform functions, various functions, or involve himself in activities of the company. That is my first submission. My second submission is
Yes.
that out of 9 FIRs, 2 FIRs are caused by the Honorable High Court,
Yes.
and in two FIRs, I am not named as one of the accused. That is FIR number 1 and 2. And 3. 3 FIRs I am not named. And 4, 5, 6, 7 FIR have been, there has been ordered by the Honorable Gujarat High Court that no pursuits have to be taken. So my second submission is that as on today, there is no schedule offense as well as this particular applicant is concerned. And there is no specific allegation of any crime, proceed of crime, no crime money, which has been in the possession of the applicant.
There is no proceed of crime in
Who are
possession,
the applicant.
in your possession.
And there is no allegation that I have used proceeds of crime in any manner whatsoever, or that I have helped any other accused in creating or acquiring or acquiring any crime of proceeds of crime.
So far your first contention is concerned with regard to you are not an accused. There is no schedule offense. So as per the ECIR, there are in total, ECIR is based on 9 FIRs or cases. Now, as per the decision of the Supreme Court, it is not required that a person should be accused in the schedule offense so as to invoke money laundering act.
But then question would arise that the definition of
Because-
crime, because a person can be charged with offenses under PMLA Act only if proceeds of crime is involved. If there is no proceeds of crime, then we will be offenses simplicity. PMLA Act cannot be involved.
No, there should be
The
schedule offense.
precondition is that there has to be proceeds
There
of
has
crime
to be a schedule offense first
and
for-
proceed of crime.
for invocation of money laundering, PMLA. There must be as per the schedule. And second is, there should be the ingredients of POC for invoking the money laundering act. So once this FIR is there, it might happen that 5% have commit are named are shown as an accused in the schedule offense. And there might be 10% who would have dealt with the proceed of crime. Then the ECIR would be against 10%.
Conditions will be-
And this question has been decided in Vijay Madan Lal Chaudhary. So that your contention,
My petition that least FIR. I'm either I'm not a party. If 3 FIRs, I'm not.
3 you are not
I'm
there.
not
That's,
a- So as far as those 3 FIRs are concerned, I have nothing to do with that. Now, 8 and 9 FIRs have been forced, so they have also become non-existent.
non-existence.
I'm not connected with that. Now, 4, 5, 6 and 7, these 4 FIRs have been virtually stayed by the Gujarat High Court.
I'm telling that as per the decision of the Honorable Apex Court. Now whether you are accused in the schedule offense or not, whether there is no charge sheet against you or not. So far as the FIR which are stayed by the High Court, we don't know the final outcome. But in any case, if we accept your submission that you are not an accused at all in any of the cases, then the requirement as per the decision of in case of Vijay Madan Lal, it is that there should be a schedule offense. If there is no schedule offense, then nothing survives.
My submission, if there is absolutely, there is no schedule offense to me. My submission is not surely that where as well as I am concerned, neither there is any allegation, nor there is FIR, nor there is any charge. 5 to 6 years have gone by. The FIRs are sometimes 5 to 6 years back.
But it might be because of the coercive action.
Then in other FIRs also, charge sheet has not been filed. Coercive action has come quite late. And coercive action always means that the accused will not be arrested. It does not mean that there will not be any investigation or there will not be any charge. Charges have not been filed in any of the offenses, in any of the FIRs. And that order was passed, was no coercive action was passed on 8/6/2017. It is already 8 years
Yes.
and no charge sheet have been filed. So these are my, that,
And second is second is that you have not dealt with the proceed of crime in any manner.
no, he has not.
And even it,
As far as he is concerned, he never had any control, acquisition of any kind of proceeds of crime, never represented person. He is required to these are my. I mind. Yeah.
yes,
For this case, the legal case in the 490 complaint. There are several accused persons.
Just one thing, so
yes,
only one query that was certificate at page number 76. Please make items.
yes.
So,
Yes.
this certificate has been issued by medical president. This is to certify that I have very carefully examined so and so, so and so, permanent. Who photograph this about and I am satisfied.
Okay, so that is the disability.
Motor disability, 80%. Permanent disability in relation to his
Yes, yes.
brain or okay.
Complaint 490. There are 7 accused persons. First 4 are companies. Now, accused number 1 company signed that was the main company, and other companies were the group of companies or the shell companies. Later on, multiple companies have been incorporated in the name of various persons, and those shell companies were used for collecting this tainted money as untainted. Now, so far as the present applicant is concerned, he is accused number 7. He is the real brother of accused number 5, Mr. Sunil Kakkar, who was managing and who was in control of all the group companies. Now, so far as accused number 6 is concerned, his discharge application was already rejected previously by the Honorable. Number 1 company, along with other group company, had availed various cash credit facilities and loans from different banks. The total amount of fraud at the relevant point of time was of 800 crores. Now, after committing willful default by creating false documents, all the nationalized banks were defrauded. Various FIRs were filed against the company as well as the directors of those companies. CBI had also investigated. Now, sir, it is an accurate fact that so far as this accused is concerned, he was not named, and we are not saying that he was there in that at the relevant point of time, because he was not named in the schedule of offense. But later on, after committing this fraud, after accumulating these proceeds of crime, the elder brother Smith, accused number 5, he left the country. The accused number 7 took charge of the company and he was made director of 2 companies. Accused number 1 SIS.
After FI left the country.
Yes.
Yes.
Accused number 5 left the country. Then he took active charge of this.
Who
But he
took-
was the director of 2 companies. Accused number 1 signed.
A7 took up he took the charge
Yes. Then he started managing.
after FI left.
Yes.
Hmm.
And he was a director of 2 companies. Accused number 1 signed Infosys, which is the main company. And the other company was EMOR, but the name changed later on to Atrium Info. So he cannot say that I was not actively managing, he was a director of these 2 companies. Now, if the honorable court may again turn to section 3,
Who's director of?
director of accused number 1 Sign Info System and accused number 2 Atrium Info.
1 and 2.
Yes.
Yes.
Now, sir, again, I may request the honorable court to read with me, or I may read section 3, offense of money laundering. Paper. Directly or indirectly attempts to indulge. So directly or indirectly, even attempt to indulge or knowingly assist or knowingly is a party or is actually involved in any process or activity. So he may not be there in the main offense, but even if he is connected with the activity, with the proceeds of crime including its concealment, possession, acquisition, or use and projecting or claiming it as untainted property shall be guilty of. So directly, indirectly assisting or indulging. These all activities are also by which the proceeds of crime are generated. It is knowing that these are the proceeds of crime, and if I deal with that property in my name, in my wife's name, in the company's name, and then if circular transaction takes place, I will point out, sir, his role from the statements. And that is how he is involved as per section 3, sir. Now, in my reply, sir, I have incorporated certain role of this applicant. Honorable court may have a look at para 9 of the reply.
Reply.
Yes, sir, my reply to the discharge application.
Para 9.
Para 9. Page 4, para 9. I may just read it. Statement of Mr. Mahesh Gante, Director of SIS, was also recorded under section 50 of the Prevention of Money Laundering Act on 14/3/18, wherein the interviewer stated that he was working as a personal assistant of Samir Kapoor, that is the present applicant, who was a director in Sign Infosys. As he is a handicapped person, that he had joined Sign Infosys Private Limited during the year 2007 as a peon. This may be noted, sir. And used to get a salary of 9,500 per month till 2013. Then company went into loss and he continued as personal assistant of Samir Kapoor as he is handicapped and increased his salary to 12,500 per month. That he became a director of Sign Infosys in September 13. That Mr. Samir Kapoor said that he would give him his huge salary of rupees 56,000 in exchange of becoming the director of the company. After becoming director, they gave him his spending dues and monthly salary onwards. That he had been director in the company till October 13. Then in para 10, there is a statement of Mr. Mihir Patel, who was a financial consultant of Sri Sunil Kakkar, Sign Infosys. It was recorded on 27 September 19, wherein he stated that Sunil Kakkar left India, Mr. Samir Kakkar take over the charge of motor vehicles and stock lying at different godowns of the company. So even the movable properties were disposed of later on. In para 11, they stated that Samir Kakkar was playing a crucial role in the business of SIS and hence he was summoned and his statement was recorded on 24/9/19, wherein he stated that he was working as admin head in Sri Sai Computer and later on Sri Sai Computer converted into Kemol Infotech and at last in Atrium. Further, he was made a director in Kemol Infotech by his brother Kakkar in 2010 and ownership of his product situated at Amarvatika was transferred in the name of Kemol This plot was used for taking the loan from the bank and same was released by a bank when Sunil Kakkar mortgaged his property for state bank. Further, this plot was transferred in the name of his wife, Srimati Himangi Kakkar, that is present applicant's wife. He also stated that in January, February, he was made a director in signing. On asking whether any amount was received by him against transfer of his ownership, Amar Vatika plot, he stated that 5 lakhs was received. So this is the amount he has received in his account. Account number 1173 maintained with Carl Goodman. So the statement that he has not received any proceeds of crime is a false statement. Proceedings was prepared to the same.
We'll continue after second.
10. Para 16, 15, where we have dealt with the para 6 to 15 of the application related to discharge, wherein one transaction related to 20 lakhs. Here that which was purchased by Sri Bhupen Sojitra Savani and Srimati Bhupen Savani, who happens to be the father-in-law and mother-in-law of the present applicant. There is a provisional attachment number 2 of 19, dated 8/11/19, with respect to 20 lakhs. Page 10 of the reply. There we have shown that how the 20 lakhs was received and then diverted to the father-in-law's and mother-in-law's name. In the same on page 11, if you honorable court may see after the tables are over. I may read this because this transaction is relevant. Further, during the course of investigation, it is found that an immovable property situated in plot number 1, Amar Vatika, so and so, was owned by RTM Infocom Private Limited. Now, this is the company where the present applicant was a director in this company. After disappearance of Sri Sunil Kakkar and resigning of Sri Sunil Kakkar from directorship of the company or making Mr. Soin to the personal servant of Samir as director of the company, the state property was transferred in the name of Himangi Kakkar, that is wife of Sunil Kakkar, on 18/9/14 for rupees 11 lakhs in cash. However, as per the statement of Sunil Kakkar, no amount was paid by Srimati Himangi Kakkar towards the purchase of the state property. Further, valuation of the state property was conducted on 16/10/19, and it is found that as on June 16, the fair market value of the property is approximately 1 crore and 41. So it was projected as if it is sold in 11 lakhs. There was no transaction of that amount. It was not paid by the wife. Actual amount was never transferred. And even the company which was the owner, there the applicant was one of the directors. Copy on page 14, sir. Ground GA L that we have dealt with the application. From fifth line on the top in that, sir, and immovable property situated at so and so. That is the transaction which I just referred. Sri Mahesh Dante is authorized director of AIPL, who used to be a personal servant of Sri Samir Kakkar, A7. Sri Samir Kakkar was director in SIS during the year 1213 and left the directorship just for 3 days of disappearance of Sri Sunil Kakkar. Then after the disappearance of Sunil Kakkar, he took over the control on all the movable assets of SIS and disposed them of as per the instructions of Sri Sunil Kakkar, which shows that both the brothers were involved in the process of money laundering with handling Kakkar. It clearly shows his nexus with his brother Sri Sunil Kakkar in the activities related to money laundering. Here it is also noteworthy to mention that one Audi car bearing number so and so was sold by Sri Sunil Kakkar to his servant Mr. Mahesh Devanappa for rupees 9 lakhs, who used to work on a monthly wage of 9,000. Therefore, Sri Samir Kakkar was knowingly involved in the process and activities connected with the acquisition, possession, and use and protection of the proceeds of crime as untainted and hence committed. So this is the role. Now, so far as the contention from my learned friend with respect to the disability, I would submit that for the purpose of discharge application, it cannot be that relevant because ultimately it is shown from the record that he was actively involved. He was the director of 2 companies managing the affairs, and after his brother left, he also acquired his properties and disposed within the family. And so far as the argument that he is not named in the schedule of offence, now the law is it is not mandatory. He may not be there in the scheduled offence, but ultimately, so far as proceeds of crime are concerned, his role is appearing and therefore he is there in the PMLA case. Therefore, the aspect of disability will not be that relevant. Therefore, sir, it is required.
Can you see para 9? To point out that in all these para, there is no role attributed to the applicant. Now, para 9 on page 4, it is like.
Yes.
During the year, it's very 9 after around 5 lakh. During the year 2007, as given and used to get salary of 9,500. That reflects on the status in the company that he was working as a peon. For month till 2030, then company went into loss and he continued as personal assistant of Sojitra as he is handicapped and he increased his salary to 12,500 per month. That he became director of so and so company in September 2030. Then he was said that he would give him rupee salary of 56,000 and he would become the director of the company. Now, all these applications do not point out towards implication with any offences. Now, kindly see figure 10. Last two line, Mr. Sumit Thakkar taken over the charge of all vigilant stock lying at different godowns of the company. So, even presuming that he had taken charge of vehicles, stocks and all the assets of the company by itself does not implicate him in any offence. Now, most important part comes in para 11. After 7 lines, further he was made director in E-Mall Import and Private Limited by his brother Sunil Thakkar in 2010 and owner that is to be marked and ownership of his plot, whose plot that is Samir Thakkar's plot. Ownership of his plot situated at Amar Bhatika was transferred in name of E-Mall Import and Private Limited. This plot was used for taking the loan from bank and same was released by the bank and Sunil Thakkar mortgaged his other property for said bank loan. Further, this plot was transferred in name of his wife Shrimati Mangi Thakkar. He also stated that in January so and so he was made a director in so and so company on asking that an amount was received by him against transfer of his ownership of Amar Bhatika plot. He stated that rupees 5 lakh was received by him in his account number so and so maintained with Applicant. So, sir, what is stated as of their own reply that the plot belonging to Samir Thakkar was transferred in name of the company for which he was given 5 lakh. And later on, admittedly plot would be more valuable. That plot was transferred in name of his wife. Now, where is the procedure for it? My own plot, for which I am being paid 5 lakh, how is it a procedure crime? It cannot be a procedure crime at all. Now, my other friend has dealt with another thing. On page 10, there are 3 reply to para 6 and 15 that again the content of these paras are wrong and has completely denied. During the course of the investigation, it was found that procedural crime in a few of 20 lakh was diverted and used for purchase of an individual property that is residential flat situated at 101 satellite Ahmedabad in the name of Shri Bhupan Girls' School. How am I involved with that? And that they have not pointed out the year in which that was purchased. But I can accepted that this flat was purchased maybe 10, 15, 20 years back, much before these FIRs were filed, and much before even the loan was taken. That is what my inspection is. That in the name of Shri Bhupan Rai Savani and Shri Sarangi Bhupan Savani hence the sharing the property to the tune of rupees 20 lakh was also attached under so and so. That is so and so. She found that from the account of Mrs. Bai, maintained the State Bank of India, the amount of rupees 20 lakh transferred to the account of Sri Sunil Thakkar, maintained the State Bank of India, and Sri Sunil Thakkar transferred the same amount to the account of and MS Bhageshwari Chawani, maintained the State Bank of India. She on the same day transferred rupees so and so to the account of Sri Mangi Sunil Thakkar for purchase of wholesale property in the name of her parents, Sri Bhupan Rai Chawani and Sri Saragi Vil. The fund flow of the said transaction can be reduced from below 20%. Now, question is that the properties are transferred, maybe in the name of people who are related, but not in my name, and I am not said to have acted in any manner to transfer this property or to purchase the property and to transfer. Neither the amount nor the property. My role has not been clearly stated that how I am involved in all this crime. That is why I pointed out, being a 80% disabled person, naturally it can be presumed that this person cannot function properly. His hands are not working, his legs are not working, his mind is not working properly. So he is 20%, a person whose total faculties are working 20%. He cannot be presumed to have worked out or to pre-plan everything and to siphon out these amounts. That is why his name is not appearing anywhere. Maybe his brother might have done all this. I have nothing to say about it. Now, if brother takes any action, hopefully I cannot implicate. That is my answer. Now, sir, in the same para, after this charge, further during the course of investigation, it is found that an immovable property situated at plot number 1, but this has been dealt with earlier para. And that belongs to, that is transferred in the name of which wife. Now, lastly, sir, on page 14, round number 3 and roughly, around 459, an immovable property situated at Amarpal Vatika. Same Amar Vatika has been repeated number of times in different paragraphs. The question is that in none of these transactions, neither directly nor indirectly, I am involved, and that appears in the report. So my humble submission that even if the entire complaint is taken as it is, there is no offense which is disclosed against me. These are mere allegations unsupported by any kind of evidence or document. So at this stage, my humble request that this applicant I might.
આરોપી નંબર 1 ને 326 હેઠળ દોષિત ઠરાવવામાં આવે છે. 307 ખૂનના ઇરાદાપૂર્વક કરેલું છે એવું માનવા કોર્ટ નથી માનતી. ઓકે, એ લોકો ત્યાંથી અહીં આવે તો ત્યારે ઝઘડો થયો છે, ત્વરિત ઝઘડામાં બનાવ બનવા પામેલ છે. પ્લસ પ્રોસિક્યુશન આરોપીને પણ ઈજા થયેલી અને મેડિકલ સર્ટિફિકેટને પેલું રજૂ થયેલ છે, એટલે એમાં એમને પણ ઈજા થયેલી છે. ત્વરિત બનાવનો ઝઘડો છે. 2, 3 અને 4 એની સામે વિસંગત પુરાવો આવેલ છે, તેથી એ લોકો શું ભાગ ભજવેલ છે એ સ્પષ્ટ પુરવાર નથી થતું, એટલે એમને શંકાનો લાભ આપવામાં આવે છે. આરોપી નંબર 1 ઈજા પામનારને ઈજા પહોંચાડી છે માથામાં, એ ધ્યાને લઈને એને એનું કૃત્ય છે 326ના વ્યાપમાં પડે છે, એટલે આરોપી ધનજીભાઈને 326 હેઠળ દોષિત ઠરાવવામાં આવે છે. 2, 3, 4 ને શંકાનો લાભ આપવામાં આવે આરોપી નંબર 1 ને સજા માટે. કોણ છે ધનજીભાઈ?
ધનજીભાઈ
ચાલો સજા માટે કોણ છે નંબર 1 તરફે? ચાલો કેટલી ઉંમર છે? પરિવારમાં કોણ કોણ છે? હમ. કામ ધંધો શું કરે છે? મજૂરી ને શું મજૂરી કરે છે? ખેતી છે? એટલે હવે જે પૂછું છે એને સાચા ને સાચા જ જવાબ આપો. તો પણ એ આપે છે તેને કહો, કારણ કે હવે સજા માટે છે. અગાઉ ગુના છે કોઈ? એમને શું ઈજા થઈ હતી બનાવમાં? બીજું કઈ કરવાનું? તમારે
ફરિયાદી પેલા ઇન્જરને એટલી બધી ઈજા છે સાહેબ કે એમ કાયમી યાદ રાખી શકતી નથી. પેરાલિસિસ છે. એક અકેલા એકલા કશું કામ નથી કરી શકતા, ચાલી શકતા નથી, ઉભા રહી શકતા નથી. 2 જણ સાથે જોઈએ એવી પરિસ્થિતિ. અને હજી સારવાર એની ચાલુ છે. એ દરમિયાન કાયદામાં જોગવાઈ છે કે પૂરેપૂરી સજા કરવી.
મહત્તમ સજા માટે